Hey folks, next up on This Week in Law, we've got Erica Johnstone, Colette Vogele, and Evan Brown to talk about happy birthday to Professor Lessig. We've got some fake patients posting fake reviews, virtual money, and thieves hoist on their own photographic petard next on This Week in Law.
Netcasts you love.
From people you trust.
This is TWiL.
Bandwidth for This Week in Law is provided by Cachefly at CACHEFLY.com.
This is TWiL, This Week in Law with Denise Howell, episode 114, recorded June 3rd, 2011. There is an internet. This episode of This Week in Law is brought to you by Netflix. Watch thousands of TV episodes and movies streamed to your PC, Mac, or TV instantly. Plus, get DVDs by mail in about one business day. For your free 30-day trial, go to netflix.com/twit. Hi, it's Denise Howell here, and we're here with episode 114 of This Week in Law, where we encourage you and we try to think hard about technology and the law. We've got a great panel of folks to do just that with you here today. Returning to the show after a long absence, we're thrilled to have Colette Vogele back with us. Hi, Colette.
Thanks.
Great to see you. And also there with Colette is Erica Johnstone. Hi, Erica.
Hi, it's great to be here.
Erica is an attorney up in San Francisco with Ritter, Costa, and Johnstone, a small firm in the city that does IP and privacy law. Do I have that right?
Yep, that's right. And also, I'm the co-founder of Without My Consent with Colette.
That's right. And we want to talk about that site with both of you in detail on the show here today. It's the reason that I got back in touch, or Colette got back in touch with me to let me know about this great site and what they're doing at Without My Consent. So we're going to talk about that in just a minute. But first, I want to welcome our third panelist, also a very frequent, if not the most regular TWiL member besides myself, Evan Brown. Hi, Evan.
Hey, how's it going? Happy Friday to you. I hope everything is going well with you. I'm like I say, or like you said, it's great to have Colette back. This is awesome. You know, we've got some great great memories, some great conversations. You know, so we're in a large sense getting the crew back together. So this is wonderful.
Yes, we are blessed. We had Ernie Svensson join us last week. We've got Colette. So we'll sort of channel Ernie by osmosis, and
right.
Know that he's out there in the ether somewhere.
He would totally be up for that. Yeah, that's the way to say it.
That's right. All right. So I wanted to start out. Well, first of all, since we mentioned Without My Consent, first off, Colette, why don't you tell us a bit about the site that you guys have founded and what its purpose is and why people should check it out.
Great, thank you. No, it's great to have the opportunity. So the Without My Consent is a project that Erica and I started last fall after we had both worked, and Erica continues to work with individuals who faced pretty egregious privacy violations online. The typical scenarios are the Nightmare X, who takes images that were intended to be private and then publishes them. You could have a Peeping Tom situation. You could also have underage people using like sexting and different types of content and not really understanding the implication of putting that content online and what happens to people's reputation as a result. We decided to form a nonprofit in January, and over the last 6 months, we've been working with students at the Berkeley Law School at the Center for, I'm sorry, not the Center for Internet and Society, that's my fellowship, but at the Samuelson Clinic for Law, Technology, and Policy. And the students there have put together a ton of information about the kinds of claims that one could bring under existing law today against a party who had posted content without their consent, as well as some very kind of procedural lawyer geekery stuff about how you can proceed in a case like this anonymously. We've both discovered in trying to help people like this that a big barrier to entry to the courts not only is finding the right lawyer and having the money to bring a suit, but also how do you pursue a claim without making it worse for yourself by bringing more publicity to the problem that you're trying to make sure people don't, discover, or the issue, the embarrassing thing that was never intended to be public. So that was sort of the impetus of it. We've worked with these students. They've given us a ton of content, which we're still in the process of getting on the site, but the site did go live today or late last night. It's at withoutmyconsent.org, and it has sort of two key features. One is some information for victims in an FAQ style question with answers. And then the harder or bigger part of the site that Erica and I are most probably skilled at getting done, is the lawyer piece, which will eventually, we hope, have the law for all 50 states, plus both substantive and procedural, as well as federal law that will help lawyers in this area understand the kinds of rights that they can, claims that they can bring to help find a way to justice for their victims of these online privacy violations. So that's sort of the nutshell.
That's phenomenal. I know that people come to me all the time with questions about this, and it will be great to have a central clearinghouse of authority and resources. And, it's just great that you guys are doing this. So much appreciated from the legal community, and I'm sure the online community in general too. Evan, you have any thoughts about Without My Consent?
It's definitely a great resource because, like you, Denise, I get a lot of questions about this because I, hold myself out as somebody who practices internet law. So my name shows up, well for searches for, internet attorney. And so these kinds of situations where somebody is being on the receiving end of kind of rough treatment online, those are very heart-wrenching cases in most situations, and I'm usually not in a position to handle those types of things because my practice is focused more on intellectual property and some other things like that. So it's great to have a resource like this to send people to, and to also in as much as it provides an avenue for people to actually find legal help for questions like this. So I'm just glad to see that it's come on the scene, and it's also even made better to see that it's being put together by such a fine crew of people whom I respect so much. Of course, Colette and Erica, and then so many of the others who are involved. Ryan Kalo, who's also a friend of TWiL, and so just a great project. I'm so excited to see it. It's wonderful.
Yes, excellent, you guys. And I love that you're focusing on the Streisand effect problem that comes up in these cases where, if you decide to take action, you actually can aggravate the situation by involving courts and media and the like. So it's good to see that issue addressed right up front, and really wish you well. We've already featured it as a resource of the week before you even went live, but it's great to be able to give you a plug here today, and I hope people will go check it out and bear it in mind if there is information about them that is floating around without their consent on the net. Which sort of leads right into something that I've been wanting to mention. First of all, it's Larry Lessig's birthday today. So happy birthday, Professor Lessig. He's 50. And out there also fighting the good fight on so many levels. So wanted to wish him the happiest, and mention that he recently spoke to the American Bar Association. He gave a keynote to them back in April. And if you're not a member of the American Bar Association or a lawyer, you may not have seen it. And it's really worth focusing. So I threw it into our discussion points today. I hope folks had the chance to watch the video. It is an updating, a dusting off of his concept of code is law. Here we go back here. The 1999 book that he published about the interplay between technology, architecture, law, societal norms, government, and how they all interact with one another, and how they should be thought about, and how regulators and lawmakers need to be aware of those interactions instead of ignoring them, as frequently gets done. So it's a great update of that, and it puts into that context some modern events we've seen happen, including the whole net neutrality controversy, WikiLeaks, etc. And I think we have queued up a bit of the talk. It's a lengthy talk. It's about 45 minutes long, but let's just play you one of the highlights if we could. It's talking about Napster here, getting sort of to the end.
Music ever in the history of human society. Now, of course, the response to that sharing by the labels was that they went nuts. They saw the largest library of music in human history as the largest example of music piracy in human history, and they launched this war to stop it, this war which, of course, had as its target these terrorists. But midway through that war against Napster, Napster made an offer to the labels. The offer was peace. They said, we'll give you $1 billion if you allow us to survive, and we'll pay you for the use of content through our network. Just let us keep growing. The labels refused. They deployed the legal system to destroy Napster, with the result in the short term, of course, that Napster was destroyed. But what was the longer-term response of destroying Napster? Populating the world with many other mini-Napsters, right? With the result, there was no reduction in, quote, piracy. Indeed, the one thing we know about peer-to-peer file sharers is, this is the date of the Grokster case, they don't read Supreme Court opinions that determine finally that file sharing is illegal. The only thing that we have done through this war is to increase the number of, quote, criminals, people we tell are criminals, aka our kids or the terrorists. And the point I want you to recognize is that all of this was completely obvious at the time these steps were taken. Given the architecture of the internet, all of this was obvious. Yet policymaking proceeded as if there were no internet here. Or another example, again, think about WikiLeaks. I concede there's lots of harmful information that was released by WikiLeaks. So recognize, though, the first thing that WikiLeaks did, what was their first offer? They offered the State Department to review the cables they were going to release and tell them which ones they shouldn't release. State Department refused. Instead, the government has targeted this behavior to destroy it through names like traitor, death penalty, war criminal, and to disable it by people like Joe Lieberman and the vice president acting as strongly as they can to get these support services taken away so the site can't exist. With the result, maybe in the short term, that WikiLeaks itself will disappear. But what's the longer term result? The world will be populated by many more mini WikiLeaks, not all of them as responsible, maybe some more responsible, but all of them providing the same functionality. This is completely obvious that this will happen, given the architecture of the internet, yet policymaking proceeds here as if there were no internet. In both of these cases, we could be much smarter in how we respond. The question, how to respond, must begin by acknowledging, here's the obvious point, there is an internet, right? We need government officials to just say this again and again, there is an internet, and to accept the inevitable given that fact.
So that, I think, is the crux of his whole 45-minute talk right there, is that government officials and probably everyone out there in the world needs to just remind themselves at all times there is an internet, and think about the ramifications of it. And that goes right back to the site that Colette and Erica founded, and how people are having to respond to there being an internet after the fact. And probably every single story we're going to discuss here today, and most of the stories we've ever discussed here on This Week in Law, if you put it against the background of there is an internet and someone sort of losing track of that along the way, that's how a legal controversy arose, and we're talking about it. So, Evan, did you watch the video, and did you have any other takeaways you want to highlight?
I did, and I mean the obvious thing is Lessig's presentation style is just really awesome. It's very entertaining, and for those of you just listening to the audio, it's definitely worth going and finding a video version of that presentation to see how simplistic his PowerPoint slides are, but yet what a rich picture it paints because it makes it so easy to follow, and it's very persuasive style. So. Yes, there is an internet, and that plays into so many of the discussions that we have here, and it really is quite fascinating at the most fundamental level to see how the things are affected here, the way that architecture and code actually can serve to form a framework for norms to play out really is something that we could only have experienced in the late 20th and early 21st century like this. I'm sure that the ideas that the way that that the modes and the channels in which people can interact have a certain way of inherently governing those legal relations among people, nodes on the network, even, many, many years before modern technology and modern internet technology was there. That's all, certainly there because of, the natural human inclination to kind of obey norms and conform one's conduct to them. But now with the web and the idea that pretty much everything that we do is a form of use or leveraging of information technology, it's so much more apparent to us now. And so it's really great to see his modernized view of this kind of, what is it now, 12 years later after the first release of the book, to see it, put in a fresh perspective with the ability to having, for example, looked at the history of the war against P2P file sharing and all of that stuff. Just wonderful to see how all of this is playing out. So it's definitely worth the 45 minutes to sit down and watch or listen to this presentation. Right.
So Perf in IRC asks a good question. He says, but just because there's an internet, does that mean you're allowed to break the law? So I guess the footnote to this would be there's an internet and there's human nature that will exploit the ability to get around the law or will ignore the law. And I guess that's how we circle back to the need for a site like Without My Consent. Colette, you want to chime in on this?
Yeah. Yeah, thank you, Denise. Actually, when I was listening to that clip, I haven't actually watched the full talk yet, so I don't have the whole context of what the clip came from. But I wonder if there's an argument against Lessig's, simple process that he, analogy between the Napster world and the WikiLeaks world. So I just want to push back on it a little, and I do this with the highest respect for him. He's one of my mentors, and I think very highly of his work. But there's nothing to say that if the government went along with WikiLeaks' proposal to review their stuff, that we wouldn't also still have hundreds of new WikiLeaks after the fact. It's not that because the government said, no, we don't want to do that, that we'll end up with hundreds of WikiLeaks. Because the government could have gone along with that, and you could have had all the different WikiLeaks. And I think the recording industry may have the same criticism of the analogy with Napster, that by rejecting Napster, they ended up with more of them. I think you could end up having made a deal with Napster and had a lot more of the peer-to-peer organizations come up. But that's just sort of one thing I wanted to throw out there as maybe something to think about, and I'd love to hear some response on that, maybe from the chat or from one of you. How this connects to Without My Consent, it is interesting because victims of the online privacy violation situation find that they end up having to whack-a-mole a lot. If they have a way of getting sites to take content down without having to go to the person who posted it, but just going to the site and saying, look, this should never have been posted. In some cases, if it's underage, you have a little more leverage because there's child pornography laws that are helpful and because the criminal law is a little more serious there. But I think that people have the problem of the architecture of the internet in addition to some of the laws that exist that make it harder to pull something down and make it obscure or get it completely removed. I mean, Erica's had some great successes in her practice, but we all talk regularly to other people who were not able to help or who decide that that route isn't going to be the most effective legal litigation route may not be the most effective way to solve the problem that they're faced. I don't know if you have any additional
and just
thoughts
to
on
add to that, one of the reasons that pseudonymous litigation is so important, and that's what we sort of try to educate people about as part of withoutmyconsent.org, is that you need to be able to assert your rights as a Jane Doe or a John Doe because of the architecture of the internet. If you were to proceed under your true name, then you're just making your humiliation complete. Because in our cases, which are primarily online invasion of privacy cases, you have a defendant who tried to harm a plaintiff through public humiliation and shame. So, if you were to file suit under your true name, then what you're doing is attracting a barrage of internet stories that are then indexed and then replicated across the web, because that is the nature of things on the internet. And you have just carried out the defendant's campaign. So in exercising your rights, you've made your humiliation complete. And so one of the things that Without My Consent tries to educate on is, the importance of having an option of proceeding pseudonymously as a Jane Doe or a John Doe. And in fact, that is in the interest of speech, because I think the public does have an interest in knowing how these cases are handled. And it's not necessarily the true name of the victim that is so important, but it's what's going on in the courts. And the way to keep those records open is by allowing Jane Doe and John Doe plaintiffs.
Well, let's shift gears here for a minute, and bearing in mind Professor Lethig's theme that folks should remember there's an internet, let's talk about money. I keep getting asked by people to discuss Bitcoin on This Week in Law. I know that it's been discussed in some detail on Security Now. I caught at least one episode where they covered it, and it just as a thing that's out there. And it seems, that's about all you can do with Bitcoin right now, except I think that Professor Lessig has given us another context in thinking about it. First of all, let me give what it is. It's a currency that is not tied to any country's currency, but is being used. It's a digital currency. People can pay for services. They can pay for goods. And it folds in the P2P aspect. In that it's decentralized, it's anonymous, and, out there surviving and thriving. And there are sites around it around, how to use it and what it is and FAQs. And, so there's a good deal of enthusiasm about it within the Bitcoin community, and a good deal of just kind of, what is this? It's interesting that it's happening, and, is it legal, and how can this go forward, and what do we make of it? So there has been some news coverage, some hand-wringing. Jason Calacanis wondered if it's the WikiLeaks of monetary policy, and it may well be. So I tossed it out there because, as I said, I think people are really interested in it. And I think it's another example of how, it may have legal issues on a number of fronts. For example, there is legislation that's now been enacted in California that requires very stiff and expensive licensing to be engaging in any kind of non-bank yet financial transaction that may well cover Bitcoin, although who knows, it's an open question. So that, the legal parameters are fuzzy, but yet who cares? There's an internet and people want to be doing this. And I'm sure that if it's squelched out of existence in countries or states who decide to regulate strongly against it and impose penalties, it will simply spring up in places where those penalties are swept aside because there are other interests that want to see this kind of transaction go forward. So, Colette, have you looked at this at all? And what do you think of Bitcoin?
I read the articles that were in the delicious links and things, and I have to say it's my head is sort of spinning because I'm in sort of the copyright world in my day job. All my extra time is spent on trying to make Without My Consent something, and then I somehow missed this whole story until I saw your list of links. And it's pretty serious, I think, and it could be very dangerous. These are things that I think the internet
enables sort of, you could call it anarchist, or you could, you think about the anonymous, all the hacking world and trying to go after the sites that made WikiLeaks come down, or, made WikiLeaks, given them some grief and some harm and some difficulties. But it makes me think there's really kind of two potential internets, and there's this whole business internet, and I think of Jonathan Zittrain, some of his talks about how we've built a lot of business and economy on this very fragile system that has a lot of problems and a lot of security problems. But nevertheless, there's billions and billions of dollars worth of business going on. That's one part of the internet. And then there's this other part, and we're kind of constantly reminded of sort of digital citizenship and what's going on. What can the crowd do something that, responds to the Bitcoin, if we want to call it a problem. I'm sure there are a lot of people out there who think this is the greatest thing in the world. But, I think in more advanced societies that are built on economies and things like that, there is a lot of concern. And so I don't know the answer, of course, but I'm really kind of blown away by some of the things that this can enable in a very frictionless way, and in a way that, certainly incumbent businesses are going to be eager to get some policy passed and some laws passed to try and stop it. And you have to ask the question, given the clip you had earlier of Lessig's talk, is policy going to be made in the absence of understanding the architecture of what we're talking about?
Right. I mean, Bitcoin solves a lot of what a lot of people consider societal ills. There are a lot of fees built into the monetary transfer transaction process that I take it Bitcoin doesn't involve. There are, of course, whole societal money-making pacts that we have with one another. There's taxation, and there's a whole, there's the idea that only a government can issue currency and control its worth, and this disintermediates all of that. Evan, any thoughts?
Yes. I think that a year from now, we'll look back on June 2011 and think, I remember when we thought, Bitcoin was going to be a big deal. This is totally a flash in the pan. And I hope, I hope I'm wrong, because wouldn't it be fun to see something revolutionary happen? But here's why I think it's a flash in the pan. So far, it's just a technological novelty. And so people get all excited, and the Ron Paul part of their soul kind of gets all, up and, excited, thinking, we can circumvent the monetary system and do all these things. So right now it's merely just a technological concept, and, it's cool. It's really neat. It's clever. It's intriguing to think about. But we are fooling ourselves if we think that we're actually developing a system here that is operating outside of the strictures of the governed world. Certainly, it may be outside of the monetary system, but what is it that we use the monetary system to do? We use it to trade value in exchange for goods and services, which each transaction then has as its basis the integrity of contract law. So if people start buying and selling stuff using Bitcoin, whether it be goods or services, and these obligations are not met, where do you go? Well, you don't go to the Bitcoin court. There ain't no judges there. You go file a lawsuit in a real, court that is overseen by the government. So if the government, if Congress or even the state legislatures want to do away with the threat of Bitcoin, they can just forget about it's a wasteful approach to outlaw Bitcoin and think, this is unconstitutional to coin your own money or do whatever, whatever the constitutional scholars are saying, this is illegal to do this. Don't worry about whether it's illegal to do this. What you do is you enact a statute that says any contract that purports to govern the relation of goods or services acquired using any, and then define, put a general definition for what Bitcoin is here, using that form of extra governmental currency or whatever, shall be voidable at the option of either party. Then people will be afraid to use this stuff because they'll go ahead and spend their money, their quote unquote money, anonymously, publicly, you know, with all the ways that Bitcoin works here. But if you don't get the stuff in return, you don't have any redress. So there's never going to be any huge transactions. And that's how you solve this problem without even getting to the question of whether or not this is an illegal coining of money. So, you know, and just as an aside, when I was thinking about this in the last couple of days working up to this, you know, there is in the same provision of the U.S. Constitution that says no state shall coin money. You know, it's up to the federal government to do that. There's also the contracts clause. So can the government, you know, intervene in contractual relations like this and say that, you know, contractual obligations are, you know, void? Like this. And there is a certain limitation that the legislature would need to be mindful of here, and that is the contracts clause of the Constitution prohibits any retroactive messing with contractual obligations, and it also binds only the states from enacting laws that retroactively affect contractual rights. So either the states individually could enact laws that say any contract for goods or services, through, you know, for which the payment is this type of digital currency should be void ab initio, or Congress at the federal level could do this. And I think that would go a long way toward making this the flash in the pan that I envision it to be right at this point.
Yeah, you may be right. I think it's an excellent point that, you know, since we're all just kind of looking at this and going, huh? And if anybody were to look at this and go, yes, what a brilliant innovation, and we're going to embrace it, you might think it would be the Electronic Frontier Foundation, but that's not what they did either. Apparently for a small amount of time, they were accepting Bitcoins as part of their donation process. But they decided actually not to do that anymore, and they sent a letter to someone who inquired. I learned about this over on our Facebook page at facebook.com/thisweekinlaw from Asher Pembroke. And over at bitcoinmoney.com, they've posted the response, which says, "Thank you for contacting the Electronic Frontier Foundation. At this time, we've determined that legal tender is the best way to help EFF support online civil liberties. When we have completed our review of the options and legalities pertinent to Bitcoin, we may make a statement. I'm not certain and I can't promise anything, but thank you for your desire to support us." So, you know, I think there's just a good deal of perplexity about this one out there. I don't know if it or its clones potentially down the road will be flashes in the pan, or some sort of gray market that begins to exist out there. You remember Linden dollars were kind of a big deal for a while. And in that environment, there was sort of a built-in justice system. And, you know, maybe we've gotten into the community and architecture pieces of Lessig's model, where those two things decide to operate in a way that, you know, end runs conventional regulation, and maybe they sort out a way to deal with the problems that you raised, Evan. But who knows? It's certainly interesting, and I'm looking forward to following along with it as things unfold. On a little bit more concrete note, we saw Google Wallet come out recently, also looking for ways to exploit shortcomings in the current way that we transact and pay for things. And immediately after it came out, there was a lawsuit that flowed from it, but it didn't have anything to do with upending the international monetary system. It had to do with trade secrets that PayPal claims Google's wallet technology is violating. So there's that pending out there. But the other interesting thing, you know, when you throw in monetary transactions with Google, I think is the privacy piece. There's so much information that Google knows about us, and with being able to have us pay for things with our Google Wallet, that just sort of sweetens up their pot of information about us even more. There is a frequently asked questions page on the Google Wallet site where it says it will not have access to users' financial information or purchase history. The company will record the time of a purchase locally on a user's phone and have access only to which coupons a user has redeemed. So toss this one out there for discussion. Is this something that you think will be a flash in the pan, Erica?
Oh, wow. This is not something that I've really followed, so I'm not sure about that one. I'm going to defer to you guys on this.
What do you think, Colette?
Flash in the pan. I think it's probably not. I don't think it's a flash in the pan. I think Google probably has longer term plans for what they're going to do and enable through the wallet. They have a lot of projects and products, though, so it's hard to say. It's hard to say if they'll, decide in a year or two that this wasn't the right way to spend their efforts, and they may regroup. I wonder if having, Sergey now again as the CEO has kind of changed their focus or helped them refocus what they're working on. I think online transactions, though, that's mobile transactions, that's a huge space, and I think a lot of people are trying to solve the problem of being able to make transactions easier via your phone or the internet, and PayPal obviously is the furthest along on the internet side, I think, but there's a lot of people, I think, trying to understand that space and make a go of it.
Right. I think that there's a lot of opportunity here, because there are a lot of pain points around how things are paid for and how payments are processed. And, Google stepping into that space. Square, Dick Costolo's company, other than Twitter, doing the same thing. So it's a pretty interesting, not the same as Google Wallet, but stepping into the space of, there is a credit card slough of fees and inconvenience that Square hopes to cut through and give vendors the ability to accept credit cards and streamline those transactions without having to jump through all those hoops. So, Evan, what do you think of all this?
One thing I've noticed about myself is if I say something cynical, then I tend to continue in that mode. So I'll just say a couple of things about Google Wallet and then try to say something not so cynical. The first thing is, when I first heard about this, I thought that it was an elegant solution that's looking for a problem. But Denise, you said that, and you pointed out very accurately, I think that, I guess there are a lot of pain points when it comes to credit card transactions like this. I was thinking, well, is it really that hard to take out your credit card or your debit card versus, swiping your phone that has this special chip in it? But, fine. Okay. Yeah, it's innovative. It's neat. It does reduce some of the pain, especially to the extent that it can reduce the fees or the transaction costs. Then, the other cynical thing I was thinking along those terms is, maybe they just had some extra office space in Mountain View, and they didn't have to redo the signs too much. They just took the old Google Wave signs and scratched out the VE and put the LLET in its place, along those lines, if this is a solution looking for a problem. But in any event, this is the harbinger of something else. It makes a lot of sense to streamline the process, even if the benefits to be gained from it are only marginal. So, it's something that is probably, the beginning of a trend here. Can't say anything about this, though, without, as you said right at the top, Denise, got to be concerned about the privacy issues here. And Google is saying one thing, and I hope that truly is what they're doing, not collecting real granular information about this, but it does seem to be information that they are collecting has to do with, the coupons or the discounts or things that you could use here. So, there's all kinds of really exciting things and interesting social media tools that could be developed. Think of with the kind of interesting things of integrating this with something like Foursquare or Gowalla or even Facebook Places, kind of making, working in those discounts kind of automatically and making yourself eligible for a reduced fee, even without affirmatively having to do something to redeem. So it really has the opportunity to give the tools to do something, do some really, really neat things with interfacing with other tools that we've already grown accustomed to.
Yeah, and again, finance is one of the most highly regulated areas of our society and the business world. So, to see things come in and try and take out some of the status quo and existing infrastructure is always a fascinating thing to watch. So we will continue to do that with the services like Square and Google Wallet and Bitcoin. See what happens with all of those. So thanks, folks, for writing in. I'm sorry we don't have more definitive answers for you. It's just such a novel concept that, I think that if it does gain some traction and begin to have an economy of its own, which, I think it already does, you might see lawmakers paying attention, and hopefully they will heed the good professor's advice and remember that there is an internet and apply that to their thought processes. Let's see if we can apply that to... Go ahead.
Oh, sorry, if I could just jump in. It does come to mind, I think last fall at the University of Washington in Seattle, they had a conference that was partly supported by the Federal Trade Commission that was dealing with mobile payments from all sorts of sides, like from the financial issues to the privacy issues to the technical issues. And I bet those proceedings are available online somewhere. It might be worth looking for that, because I think the listeners may, if I can find it, I'll send it to you. I think it would be an interesting place to look for the thinking around this from a sort of policy and law standpoint.
Great. I've got all our discussion points for the show up at Delicious, as long as Delicious continues to have a place where things can be up. I assume that's going to continue after their changeover, which I think happens in July. But that's delicious.com/thisweekinlaw/114 for our episode today. So I'll add it there if you turn it up, Colette. Someone who doesn't seem to remember very frequently that there's an internet, although she's a frequent user of it, is Courtney Love, who has been sued yet again for Twitter-based defamation. I think she should write a Defamation for Dummies book, because she's, one of the most experienced people in this realm right now. But yet she's got another suit. Evan, any thoughts about this one?
Oh, bless their heart, and bless her former lawyer's heart for filing this lawsuit. I mean, seriously, this just demonstrates. I mean, what has happened here? She said something bad about the lawyer who represented her in Courtney Love's first defamation lawsuit, the one that she ended up settling for $430,000. And so she said something bad about her lawyer, like her lawyer had sold out or something like that. Something somewhat innocuous, really. So she's getting sued by her former lawyer.
An assertion or an intimation that they might have been bought off.
Yes, perhaps. I mean, it's not like she, I guess it might be what they call defamation per se, where it's so inherently harmful that you don't even have to really spend too much effort in showing how, it's hurtful to you. I mean, it could have been worse. Like, she could have said much worse things about her lawyer. And so, I mean, I just think that this demonstrates the extent to which, all of these folks, oh gosh, I hope I don't get sued here, that they're operating outside of the kind of reality that 99% of us inhabit. Come on, let's get on with it. Let's move on to, when is the next time that Howell is going to release a good album, if they ever care to? Again, it's no longer 1995. Let's move on.
Yes, absolutely. So, Colette, I don't think that this is a terribly good candidate for Without My Consent.
No.
But
No.
She just seems to have an unbridled love of Twitter and speaking her mind. What do you think?
Yeah. I mean, I think for Without My Consent, we're really more focused on right now on use of primarily images or other private information. This doesn't sound like a private, privacy related issue.
No.
But yeah, it does. It is very odd. I was wondering if the lawyers waited till after the statute of limitations for a malpractice suit before filing their lawsuit on defamation. And I don't know what the statute is for defamation, so maybe they couldn't wait that long. But it's, you don't really want to sue your client until that statute's over, I guess. So,
yeah, good point.
Maybe that's my point of cynicism for the day.
I think another point, too, is just to think about what lawsuits you file, because there's a narrative that develops from, who's filing what lawsuit. And if you file a really frivolous or silly lawsuit, then that can do as much damage to your reputation as whatever the content of the lawsuit actually is, because everything that you file is going to be public and, held up to scrutiny and will be mocked if it's ridiculous and that kind of thing, too. So I think that people can be a little
savvier maybe about, which lawsuits they choose to file or not.
And we've addressed that theme a number of times on the show. I'm sure you even remember it, Colette, about how lawyers, file some of the craziest pro se lawsuits. They're just crazy, silly stuff.
Yes.
Yeah.
Well, we have a whole topic that we cover frequently on the show, litigating in public, remembering that there is an internet. And why don't we talk about Joseph Rakowski and what went on there? Evan, we were going to try and get to this last week. It's fairly humorous. You want to bring us up to speed?
Well, sure. It's this, I don't have the story right in front of me, but, just kind of talking about it in general terms. I think is this all happening in New York? Or I know he's a lawyer out east somewhere, and he was admitted pro hoc vice, I believe, in the District of Columbia to represent a guy at trial who was being put on trial for murder. And this was the lawyer's first trial that he ever handled. And long story short, the judge ruled him to be incompetent, and I don't know exactly how that came up procedurally in all of this, but, I guess there was a mistrial, right? Correct me if I'm wrong, because I'm just going by memory on all this. So instead of instead of the lawyer realizing that he was out of his league, and should have probably maybe tried a couple of speeding ticket cases at least before handling a murder trial, he went on the defensive against all of these people who were criticizing him in the blogosphere, suing a bunch of people for defamation. And who's the guy's name? He writes like the New York Personal Injury Law blog. I know that he had a great article about this. I think it was in our show notes. What was his name?
Eric
Denise?
Turkowitz.
Yes, out there over there in New York. And so it's just a very humorous post that Eric wrote, because he's actually been one of the defendants in this defamation lawsuit that this Joseph Rakowski, I believe is his name, this young lawyer out there has filed. So this is just right along the theme that we've been talking about here on the show about how filing these lawsuits from some kind of really weird righteous indignation standpoint like this can make you look so much worse than if you just, first of all, don't get yourself in this kind of trouble to begin with. And second of all, if you do, probably the last thing you should be doing is going around suing people for defamation if you're embarrassed by the fact that they have brought to the light of day some of your misgivings or shortcomings, I guess is the word I'm looking for.
Yeah, I mean, I guess the moral here and why it's worthwhile to discuss is that in the past you could maybe fire off a blunderbuss approach. As Eric writes, he sued everybody, including the Washington Post, the American Bar Association, and Thomson Reuters, several lawyers. He hasn't sued the judge, so who knows? Maybe that'll happen too. And in days gone by, you could do something like that and, maybe make a few people angry and maybe get sanctioned by a court. But, the public humiliation aspect of it was not what we see today. And, in blog post after blog post and talking about it on our show and et cetera, Joseph Rakowski is not going to recover from this action of his reputationally, I think, probably ever. So, it's another object lesson in there being an internet as you go about your daily life. Even many years from now, when he is in his 50s or 60s or whatever, this will be showing up in whatever form of search results we have available to us, with that day's technology. Because you remember it's been a few months ago now, that whole story about the lawyer who wrote the silly letter to the Cleveland Browns saying that he was afraid of getting his eye poked out. And that was in the 70s when he wrote that letter. And so, look at how, antics from those days, kind of this blunderbuss, overzealous plaintiff lawyer kind of attitude can come back and haunt one and still be associated with one's identity 30 plus 35, 36 years later. So it's not looking too good for this guy and his, unless he can somehow embrace it and see the humor and kind of, Cato Kalin it or something like that, or Elliot Spitzer it, that would be the
if he can somehow embrace this, he could turn it into a positive. Give me a call.
Right. Maybe this is all some grand publicity scheme. Who knows?
Right. Yeah.
Erica, I'm sort of chuckling to myself, imagining the scenario. I read on your firm's site that you help people and advise people on rehabilitating their online reputations. Maybe Joseph should give you a call, but I don't know that you're necessarily dying to have him as a client.
I mean, we do help people sort of reclaim their reputations, and a number of ways you can do that is just, contacting intermediaries on your own and writing a letter and explaining why the content is offensive and ask whether they'll take it down and that kind of thing. And then also there are sites like Reputation Defender that help you reclaim your reputation. But I'm not sure that this, particular case we could really help with.
No, if you've done something.
It does make me think about, It does make me think a little bit about the whole, the right to be forgotten, the European or French proposal. And there is a deeper privacy question and very academic kind of and historical privacy question that we could tease out this sort of scenario. Like maybe he does get the light of day at some point. He does recover and realizes that wasn't the best way to handle this. But this is going to tar his reputation forever, potentially, as a lawyer. Even if he is a very good lawyer, I have no idea. But, maybe in some aspect of his practice, or he becomes, I don't know, does some area of law that we really need people to practice in. And, he can't rehabilitate and get on with his career, and people will lose services because of that. I mean, there's another side to the story potentially, but it does sound like a pretty hard guy to defend right now in this scenario.
Or he has also developed expertise in what not to do, so he can become an expert on what not to do.
Right. He can join Courtney Love in writing how-to books for others.
Comes to
how not to.
Background.
Here's another how not to. Erica, you mentioned companies that will help you rehabilitate your online reputation when it has been damaged in some way. Apparently, one of those companies is called Medical Justice, and it tries to help doctors who are up in arms because there are negative reviews and comments about them out there on the web. And of course, doctors are no different than anyone else. There could be a legitimate negative review, or there could be something completely fabricated and, going after them in some sort of false and vindictive way. But so, I could see why a company would want to cater to that need, but Medical Justice apparently went too far. This is from a story at Ars Technica by Timothy B. Lee. And what Medical Justice did was to go against Yelp's terms of service and create false accounts for ephemerally and fictionally happy users or patients of these doctors.
That's a great way of putting it. What did you say? Ephemerally happy? Something?
Ephemerally and fictionally.
That's great.
They cobbled together fake accounts and tried to seed positive reviews for the doctors. Of course, that is the terms of service violation. I don't know if, I'm interested to get your thoughts on any other legal consequences of doing something like that. It certainly seems like an unfair business practice. Colette and Erica, let's start with Colette. What do you think of Medical Justice's tactics?
Oh, I'm not a big fan. I have issues with use of the contract to transfer copyright, and then we use copyright as a pretext for removing things that are really in the realm of free speech. This tactic, though, it kind of seems a little predictable to me that we'd be here today. What I know, little I've known about them over the last 4 to 6 months when they kind of came to my radar, I'm actually not that surprised. It's sad to say, but I think that legally they have terms of service issues, contract with that's a Yelp claim potentially, but then I think other providers of services in the same space as the people they've made the fake accounts and fake ratings for,
could potentially look at this as a potential unfair competition. It's false advertising potentially. I don't know if you could call it advertising, but I think there might be a claim in there. That's kind of where I'm heading. Do you thought of anything else?
Yeah, I mean, the two obvious claims would be sort of breach of contract, for breaching the terms of service, and impersonation. But I do have to say, I think there are two sides to this whole medical justice story, and I think that medical justice, probably crossed the line of doing the sock puppetry and fabricating reviews and stuff like that. But I am sympathetic to doctors and therapists who, and especially therapists who have, built their careers over their lifetimes, and then especially therapists who are dealing with maybe court-ordered patients and stuff like that, who have a lot of hostility and animosity, and they're making custodial disputes. And a lot of that gets transferred onto the professional who's involved in the case. And so, doctors and therapists, where there is this confidential relationship, are really sort of at the mercy of people who might want to sabotage their careers by writing these online reviews that are, defamatory or really hurtful, or at least create this drama around the professional so that clients don't want to go to that professional. And they have a lot of power in those online reviews. And so I just, I sort of understand where medical justice is coming from. I just think that they crossed the line on this. And another way that I think that, doctors and therapists could take control of their reputations is by having everyone who comes to them for services fill out a review. And that way it's kind of a numbers game, but if you have hundreds of clients who are relatively happy with your services, then the one or two outliers that are, bent on defaming you or destroying you online are outnumbered by, the hopefully positive reviews that you have.
Right. Unfortunately, the tactic seems to be the opposite of what you just suggested, Erica, and that there are provisions in some medical providers' patient agreements that require them not to give reviews. I'm not sure if they try and outlaw only negative ones, but there are contractual patient gag agreements, if you will, in many doctors' agreements with their patients that they not say bad things about them. Evan, do you think those are enforceable?
I wasn't familiar with any that just out and out try to prohibit reviews. And if you say that they exist, I believe you. I'm certainly not trying to dispute that. I had just known of the ones where the doctors try to grab a copyright assignment in whatever reviews that the people do write. And then if they see a review about them that they don't like, the doctor will then, go DMCA on the service provider and have it removed there. So there's no doubt that is, either forms of those is just a terrible business practice. And I'm confident that it's such a bad business practice and so sours the process and would serve to delegitimate the process that just kind of by natural selection of some sort, that kind of content will be viewed as so, those kinds of tactics will be viewed as so unhelpful. And the kind of content that we're talking about in this, the thing that precipitated our discussion here, these kind of fake, ephemerally satisfied and happy reviews or whatever it was you said, we've got to remember that. All of this stuff just puts it all so out of balance that it's going to work its way out and not, be part of the calculus as things get more normalized here. It just seems so antithetical to openness and the freedom of communication that's so critical to the way that the open web works, that I just can't see it lasting for like something akin to market forces will drive these kinds of things out of existence, I hope.
Yep, one can only hope. Well, somebody who would have been wise to remember back in 1996 that there was an internet, although it was just sort of coming into its own at that point, was Mikey from the movie Swingers. And he stars in our Netflix pick of the week here, which I'd like to go ahead and thank Netflix for sponsoring This Week in Law. Swingers is available on the Netflix instant service. It's one of my favorite all-time movies, and Mikey is the guy who left the world's all-time greatest voicemail for, I believe it was Nikki, his girlfriend, over and over again. And of course that would have been on the internet in today's day and age. Back then he only had to deal with his own humiliation of having left the thing and the ramifications of having done so. But if you can deal with the angst and hand-wringing of Mikey's humiliation, it is a good movie, and I encourage you to go check it out on Netflix Instant. Of course, Netflix you are probably already familiar with for delivering DVDs directly to your home. It also lets you watch thousands of TV episodes and movies instantly, and part of your monthly subscription streamed directly to your PC or Mac or any Netflix-ready device, including tablets and Xboxes, PS3s, Nintendos, Rokus, DVD players, all kinds of ways to enjoy your Netflix Instant these days. And you can watch as many as you want, anytime you want. There are never any late fees or due dates. But what there are constantly new offerings being added. And I think that Swingers is fairly new to the Netflix Instant catalog. So it's fun to watch what comes online there to be able to enjoy. I mentioned that one was made in 1996. It was directed by Doug Liman and, of course, also starred Jon Favreau, who's very funny as... I'm sorry, it did star Jon Favreau, but also starred Vince Vaughn, who is also very funny as Trent, the would-be actor who purports to be an expert in all matters of the opposite sex. So I really enjoyed Swingers, and it's great to be able to watch it whenever and wherever you might be, and you can do that with Netflix Instant. So please go to netflix.com/twit and sign up for your free trial. Then you can try it out for yourself and see all the incredible titles they have, both in their massive DVD library and at Netflix Instant. So thank you so much, Netflix, for your support of This Week in Law. Let's see. We've got so much else to discuss. Wondering if we should go for the light or the serious. Another thing that people keep asking us to get to, so I'm going to go ahead and put it in here so we don't skip right over it, is the LoadSys patent case against developers in the App Store and the extent of the licensing that may cover those developers on Apple's behalf. This is something that Matt McCurry has written about extensively and has been following. It has a new development this week in that LoadSys, who is going after these developers, claiming that they came up with something that has to do with accepting their in-app payments, doing transactions within the app. Apple is claiming and has written a letter, which again, speaking of litigating in public, the letter came out, I think, on, I'm not sure which of the Mac rumor sites. If somebody remembers, go ahead and let us know that. But it's not a letter that I think was intended for public consumption, but it has been out there online and outlines exactly what Apple's statement to LoadSys was, and that is that they think that they have licensed that technology and all their developers are covered under it. LoadSys disagrees. They have sued a few developers now and just this week have offered to actually pay those developers $1,000 a piece. They've done this on their own site, made this offer if it turns out that Apple's license actually extends to them. So, you know, for their trouble in being sued, they're offering $1,000. Because they're so, let's see, Matt McCurry over on our Facebook page says, I think they've only accused around 13 developers, so it's not exactly a meaningful gesture. In fact, it's laughable. But this goes forth. Evan, any thoughts about LoadSys?
Well, and the people who are following this are, so into it and have such, strong feelings about it. My, my puzzlement or my bewilderment is the same as most, general reasonable observers here. What is it that's LoadSys's real motivation here? It has to be something other than actually extracting a few pennies from each of these developers on a case-by-case basis, because even if the court were to grant them everything that they're asking for, it would be just a few $1,000s for every $1 million of revenue that one of these app developers brings in. And I know that most app developers that I've represented are not bringing in more than $1 million a year, as notwithstanding the fact that all of my clients are very, very smart and successful people. So there's got to be something going on here that's other than that. It has to be some kind of communication to Apple. So it's very subtle and kind of a weird way. I purport never to I guess I will never purport to understand the mind of a plaintiff in this kind of lawsuit, which we can in a friendly way call a non-practicing entity, or more unfavorably call a patent troll. Even if it does actually have some kind of valid rationality to it, I don't always see that reasoning as sound. So I don't have anything really to add on this other than to remain a bit bewildered as to really what's going on here, and to see some amusement in Apple's response, which makes a very interesting intellectual property argument under what they call the exhaustion doctrine, or the first sale doctrine, which is more of a copyright concept or terminology, but in patent law, the exhaustion, they've got the license to this technology, and so the utilization of this technology in the process of development is not something, this is Apple's position, not something that should be give rise to patent infringement liability, because the patent rights were exhausted at the moment it was first licensed. So there is, in the midst of all this bewildering situation, a very interesting intellectual property issue that would be quite interesting to see played out. But I suspect that something will come of this before it gets to the summary judgment stage, I imagine.
Yeah, this isn't just your garden variety patent trolling either. It's sort of distributed long tail patent trolling. The notion being you would have to hit so many developers for little tiny bits of money to be able to really justify undertaking the legal action involved here. Erica, any thoughts on this one?
No, I just pretty much agree with what you guys have said. I'm a little bit bewildered. I know that Apple claims to have licensed the technology, so we'll see where that goes.
Colette?
Yeah, I do think it's interesting. Given the marketplace in the app development system, and Apple has certainly the furthest along in developing their phone marketplace, so in the app community. So what's interesting a little to me from the just sort of outside observer PR kind of thing is how some developers over many years have gotten frustrated because it's such a black box when they submit their application. They never know what the decisions are going to be made about what gets passed through and what doesn't. And now they're at the same time, I think, very happy and thankful that Apple's stepping in and doing something. So it just is an interesting lesson in how you treat your developer community, and businesses are in a hard position, and I think the platform providers can be in a hard position in trying to court that community and also run their business.
As long as we're talking about Apple and lawsuits and legal procedure, it's interesting to note, too, we've covered Apple versus Samsung and Samsung versus Apple before here on TWiL. Just a little sort of interesting hiccup in that case is as the discovery process is unfolding, both sides are now demanding their unreleased prototypes from one another to be able to support their trade dress and other claims. You just have to smile when you see large commercial phone manufacturers, Samsung for its part asking for the iPhone 5, Apple perhaps more legitimately asking for products that Samsung has had a lot more details about in the market, even if they're not formally released, including giving 5,000 samples to the folks at Google I/O of the Galaxy Tab 10.1. Evan, as our litigator and discovery maven, any thoughts on this one?
It's entertaining to us because it's the Samsung and Apple case, but you know, the arrangements like this and discovery of sensitive information are not uncommon at all. One of the important constraints on this is that it's just for the outside attorneys only to review. You know, that's a very common practice when, you know, parties are exchanging sensitive information. So, you know, the other side, Apple's outside lawyers, are they going to be the only ones to see the Samsung stuff, not even, you know, inside lawyers with Apple. So, you know, it's fun to think about, and it's like, oh, haha, look, you know, there's all this stuff going on, and poor Samsung has to turn this over. But it's in whether it be a patent case or any other type of general commercial dispute, there is going to be a lot of sensitive information, commercially valuable, trade secret kind of information that is going to form part of the body of evidence and all of this stuff. So there are procedures in place and mechanisms in place to protect the sensitivity of that information while still allowing the dispute to be fully heard and protecting all of those interests. So, yeah, this kind of stuff is just inevitable when you have sophisticated litigation happening, going on.
Those procedures and constraints sort of assume the ethics and responsibility and compliance of all the lawyers involved and of the parties involved, you know, the in-house lawyers and members of the executives corridor of those companies frequently visit their outside lawyers' offices, and those prototypes will be right there. It might be almost too tempting to not take a look, but
I'm sorry that my cynicism rubbed off on you.
It did, but I'm also remembering that there is an internet, and if, you know, two similar things start creeping up, we're just going to have another slew of Apple and Samsung lawsuits to discuss.
Right. On that point, I mean, you know, you do raise the concern that the client always had when it's the one that has to turn over information to the other side. And even if it's attorney's eyes only, they think, well, what is that going to mean? But, you know, lawyers take that obligation seriously to obey these court orders. So I'm saying this for the benefit of everyone listening or watching. You know, you have to trust in the good faith of the participants, you know, the lawyers, both on, you know, representing you or on the other side. It's very serious to violate one of these protective orders. So it would be the extreme renegade, one who is, you know, risking not only his good standing with the court, but maybe even the law license to violate one of these protective orders. So it's the best we can do, I think.
Okay, that's good to know. Hey, we do have a story that is up the alley of our Without My Consent folks, and that is there's a suit in New York, a class action suit on behalf of Facebook users in New York State under the age of 18 who have had their names or likenesses used on a Facebook feed or in an advertisement sold by Facebook without the consent of their parent or guardian. Erica, have you taken a look at this suit and you think that there's merit to it?
You know, I haven't looked at this particular suit. I mean, there's, you know, obviously sort of rights of publicity involved, and consent to the use of your image or likeness is a defense to, you know, the cause of action for violation of the right of publicity. And so I guess the issue is whether the younger people were able to consent to the use of their photos or not. And, you know, I think that I'm not sure. I haven't really looked into it any further than that.
Right. Go ahead, Colette.
I was going to say it'll turn on the state law question, I think. Whatever state, if it's New York, then their right of publicity laws, and also contract laws and the ability of a minor to consent. And I don't know, Facebook wasn't around when I was a minor, so I've never had to look into this question for myself. But I know that when I joined Facebook, you know, you had to consent to certain things always being available in public. And so, yeah, I think the question will be, could a minor do that, make that consent? Can Facebook rely on that?
Right, and I guess we should just clarify that you can be a minor and on Facebook, that's okay. There's this area of folks between 13 and 18 who would fall into that category, although, of course, Facebook has taken flack for, in practice, having people under 13 on the site. They've taken some flack in Washington about that lately. Evan, this is kind of low-hanging fruit, I think, bringing this sort of lawsuit. Is it a taco suit?
I don't think so. I think Facebook actually has something to worry about here because, like Colette said, it's going to depend on the state law, and there's really nothing in the Facebook Statement of Rights and Responsibilities that particularly addresses this, that even purports to get the consent of the parents, for the use of the minor's name, image, or persona, or however, it would be characterized here as the violation. And even if it did, I'm not sure that would have much of a legal effect and actually serve to immunize Facebook from some kind of claim like this. So I think there actually may be something that Facebook needs to be concerned about here. One other kind of it's just merely academic. It would never work out in reality for a number of different reasons. But I thought it was kind of a little bit humorous in Facebook's rights and responsibilities. It says that if Facebook gets sued for anything that you do while using Facebook, you agree to indemnify Facebook for, its attorney's fees and costs and damages in connection with that. So wouldn't it be kind of clever if Facebook then goes to these minors who could have set their profile to, not display their name or image with these ads, but then they didn't do it, so they go to them to seek indemnification because they got sued by their parents. Obviously, that's not going to happen, and it would break down both factually and legally. But it's just one of those things that popped into my mind when looking through the Statement of Rights and Responsibilities. You got to remember that when you sign up for Facebook, you do make that promise to Facebook that if Facebook gets sued for something that you do, Facebook is going to come to you to pick up the tab for that.
Wow, that is a funny observation and could come up in a lot of different contexts besides just this suit.
Right.
Before we wrap the show today, I want to, since Colette has in the past done a lot of research and writing on music licensing issues, I want to get to our cloud music triumvirate out there, Google Music, Amazon Cloud Player, and Apple iCloud, and just sort of toss out to you guys, what you think these things represent, and revisit the issue of, at least in two of those instances, no licenses with the music labels. Colette, any thoughts?
Denise, I hate to do this to you. We didn't talk about this before, but I really probably shouldn't comment on these given my job for Microsoft. And I think about these still all the time, and I think it's really a fascinating disruptive thing that's still happening in the music industry. It's just taking new steps. And I just would rather kind of sit tight and hear what you all have to say, and maybe Erica has a thought or Evan.
Yes, good point. As senior copyright counsel for Microsoft, this is probably not something that is necessarily the greatest thing for you to talk about in a public setting. So, Erica, what do you think?
This one's not for me. I'm going to defer to you guys.
All right. Has anybody even tried them? Kick the tires? Any thoughts, Evan?
I like the Amazon. I've tried Amazon Cloud Player. I haven't tried Google. But is Google out of private beta? I haven't gotten an invitation. Well, I haven't tried it.
Yeah, it's still invitation only, and I did get my invitation and tried it. So
I'm such an outcast. Nobody ever invites me to anything. So haven't tried Google. But and I've said this before on the show. My perspective really changed when I first used the Amazon Cloud Player, and I realize I'm a decade late to this. MP3 Tunes has been around for forever, and there have been other music lockers for a long time. But it really has revolutionized the way I think about things and underscored for me the anachronisms in copyright law, that this is still an issue, that this is, you have this music that you have, and we'll just, for the sake of discussion, just say purchased. I know that there are all kinds of nuances and people can disagree with whether or not you actually purchased music when you purchase music, but it really matters not where it is. If you've bought it, it shouldn't matter what device it's on, and there's just nothing meaningful for the rights holders to hang their hats on to say that you should get, an extra bite at the apple just because somebody's loading it onto another device. And so the more that I have used these technologies and become familiar with them and integrated them into my media consumption habits, the more silly I realize it is for the rights holders to, look at technicalities and anachronisms in the Copyright Act to extract more licensing revenue from this.
Yeah, I think it's interesting that Apple has gone ahead and apparently, I mean, this is all rumor at this point. We're still waiting for the iCloud announcement. But from what we understand, Apple has gotten its licensing ducks in a row and is going to be able to offer functionality that the others do not, that you're not going to have to go through this upload process of your music library, that Apple's going to know if you have the rights to the music that you've purchased in the past, and it's going to be able to simply just open up a cloud service that acknowledges that those rights extend that far. That's what they've been negotiating, presumably. So that will be, one less hurdle to jump through for users. That'll be nice. I also understand that it's going to be a for-pay service, which the others are not, at least not at the minimal level of storage in Amazon's case. I did accept my invitation and did the Google one, and it's not really relevant to the legal discussion, but for once, Google seems to have nailed the UI and user experience a little bit better than the only other player out there I've tried at this point, which is Amazon, which seems kind of clunky in what you have to go through to get your music up there and enjoy it. Google seemed a lot smoother and faster and easier overall. So kudos to them for that. And it does seem like, these cloud services are going to be the wave of the future and hopefully marry together the good things about having one's local library and being able to access it anywhere. We're just going to have to see if maybe, when the Apple iCloud offering, which is done with permission, comes out, if the other two are going to feel the ramifications of that. Do you think they might, Evan?
It's hard to say. I don't, there's just going to be a big, I guess what I'm trying to say is something's got to break here with, the renegade behavior on the part of Amazon, and, kind of at best there's ambivalence or, kind of mixed messages that the other two are coming from, with their licensing arrangement here. So really, to address your particular question, I think it's anybody's guess. And, we might as well flip a coin on some of this stuff, how it's actually gonna shake out.
Right.
I get, what do you think? I mean, that's an interesting way that you formulated the question.
I think we might have to wait till August when the judge is going to rule in the EMI case against mp3tunes.com, where there's a good article about this from Gavin Clark at the Register, just basically setting the context and reminding us that we're going to have a decision in that case later on this summer. So, if music lockers get shut down there for operating in an unlicensed way, then the backlash for Amazon and Google could come home to roost at that point. So I'm staying tuned.
That's great.
So we're going to go and give you our resources and tip of the week. I'm going to start with our tip of the week, which is a funny little anecdote. It seems like not the first time I've heard of this happening, but it does seem to be the kind of thing that happens more up in your neck of the woods, guys, in San Francisco. There's a gentleman named Joshua Kaufman who lost his laptop in Oakland, I believe. And he had an app on the laptop, and this would be, I guess, our tip of the week, that you can catch laptop thieves by using an app like Hidden, which you can turn on to begin taking photographs remotely of someone who might have your laptop. So he did this and started posting pictures to Tumblr at a site called This Guy Has My MacBook. And the pictures are, yes, there we go, not terribly flattering pictures of some as then unidentified fellow who had made off with the thing. And he was able to provide that information to police. And a couple months later,
there's the one.
they swooped in and got the guy. So there he is using the stolen laptop.
Did you really just say he's using the stolen laptop then? Anyway.
I did.
Okay, fine. Yeah.
So there we go. Someone else who should remember that there's an internet are laptop thieves. And as long as we're on this, I do have some qualms about being able to load up computers with software that you can turn on to take pictures remotely in any context. Erica, any thoughts about, obviously this had a happy ending, but you can, and I'm sorry.
Sorry, we'll delay
favorable conclusion.
I'm just sitting here.
Yeah, exactly. But you could conceive of ways that software like this could be used in not so law-abiding of a fashion. Any thoughts on that?
Absolutely. I mean, I remember there's a story maybe a year ago about schools that had issued laptops to their students and hadn't told the students that they had the same type of photo-taking capabilities. And so the students would bring their laptops home, and the school proceeded to photograph the students in their bedrooms and that kind of thing. So any sort of recording device where people are unaware that they're being recorded leads to potential invasions of privacy. And since there is an internet, those invasions can be spread quickly. And that's why we have withoutmyconsent.org.
Right. Colette, do people just constantly in Northern California load up their mobile devices with surveillance technology?
I don't know. No, I don't know. I actually moved recently to Seattle, so I can kind of distance myself. I don't know what goes on here anymore all the time. But, it makes me think. I thought of the same case that Erica just mentioned from about a year ago. And it also makes me think, if Hidden is the name of this app, I'm going to just put a sticker from their company on my computer, regardless of if I have the software. Because now anybody who wants to steal my computer might think I have the software and won't steal the computer.
It's the new beware the dog.
Yes. So, maybe there's a freer, cheaper way to do this. But no, I see some pretty, I guess to avoid the consent issue, maybe you can put a sticker on your computer that says, I have the software on here, and if you use the computer, you're consenting to my taking these photos. I don't know how enforceable that would be, but in the stolen laptop scenario, I think you have a pretty sympathetic story. Other scenarios, these things end up being very fact specific. But yeah, I did lose my iPhone once, and I was very glad that it had the software on it that I could track where it was, and it was left on BART, and somebody returned it to the BART, Bay Rapid Transit Center thing, and I got my phone back. But that's a different kind of surveillance, I guess, when you surveil yourself or your own thing.
Yeah, just tracking where it was is not quite the same as flicking on a camera, although everyone in IRC is saying this thief had no expectation of privacy.
Yeah.
I don't know. You probably do waive those sorts of considerations by committing a crime.
Right.
I think that one pic was probably just a screen cap from chat roulette, not from
Yes. Thank you for clarifying for our audio listeners only what we were laughing about at the time. Our resources of the week, one of them is a project of one of your colleagues, another fellow at the Center for Internet and Society at Stanford, Colette. You brought this to my attention. It's called Define the Line. It's in Canada. And it's pretty informative and useful. And its purpose is to clarify the blurred lines between cyberbullying and socially responsible digital citizenship. You want to add any detail to that for us?
I met Shaheen Sharif through the center and through the program that I'm still affiliated with. And I know Eric has met her in person. And she has this very ambitious project being run out of McGill University. And she does, I think, have intentions to also look at this problem in the U.S. I think it's not, her site, although it's out of Canada, isn't solely focused on Canadian issues. And I think that it's going to be a really interesting place to work on that question of how do you work with youth and understand and teach the differences between cyberbullying, which is just an online form of something that kids have been doing forever, and how to use the internet in a more socially responsible way, because it's there, it's going to be used. We need to understand it. We need to be talking about these issues. And, I don't know all the details of her program. I think she would be lovely to talk to and have her give some more information at some point. And maybe even be on your program if you have room in the future. But she's just very articulate and has really put a stake in the ground around these issues from her vantage point up north.
Yeah,
Right.
and I think that, she sort of focuses on teens and how teens are playing with their identity online and carving out what they perceive to be maybe a private space that's not necessarily private. And so a lot of the issues that she deals with are sort of unique to that particular age group, and, should you treat the internet like a diary or not, and sort of the laws that come into play when dealing with underage minors as well.
Yes, so that you can find that at definetheline.ca. When I read it, I thought it was a great resource for younger people who are using the internet, and it's someplace that they should check into, and maybe their parents should encourage them to check into, because there's a lot of good information for them there. I'm noticing in IRC, as people continue the discussion about Joshua Kaufman and catching the crook with the laptop, that this is reminding me a lot of the kinds of tort questions you would get in law school, where you would have a criminal committing a crime in some unsafe environment, and the floor falls out from under him, and then he tries to bring a lawsuit for unsafe premises liability, that kind of thing. And some of those were pretty gray areas, and that's why they were on our exams. There are certainly situations and activities where you will waive any other rights that you may have had. But when you get a little bit removed from the act of committing the crime, you actually do get into an area where your safety and privacy and things are still safeguarded. Evan, you want to give us any final thoughts on that before I give us our last resource?
Well, I guess you can just never underestimate the silliness of a claim that someone's going to make. Those are in many ways the original taco suits.
Yes, they are the original taco suits. Okay,
as
so
opposed to the Supreme taco suits, because the Supreme taco suits have sour cream and tomatoes.
Yes, and both a crunchy and a soft tortilla.
Right.
Hopefully. As a final birthday gift for Professor Lessig today, I also want to highlight yeswescan.org/Lessig. And this is a project where it's possible to sponsor scanning a volume of the first series of the Federal Reporter of the United States. You can make a tax-deductible contribution of $1,200, which seems a bit stiff, but if you're a law firm or a business, that's certainly something that is nice to be able to write off. And that will pay to double key 1,000 pages of the federal appellate opinions, and copies will be donated to the National Archives and the Government Printing Office. Your name and the link of your choice will be inscribed on the public domain wall of fame, and in each case, your adopted volume will be a separate HTML file with a common footer. This volume of American Law was transcribed for use on the internet through a contribution from your name here. So if you or someone you know might be able to adopt and sponsor a volume of the Federal Reporter, go over to yeswescan.org/Lessig. And it would be a nice birthday gift for someone who's done a lot for cyber law, Professor Lessig. So we thank him. And I thank all of you for being on This Week in Law this week. It's been fun. Great to see you again, Colette.
Yeah, thank you very much, Denise. It's really fun to be back, and especially in this context.
Absolutely. And folks can find Colette at vogelaw.com, and she is also Vogelaw on Twitter. So I hope it's not so long between visits again, and we can get you back on again soon.
Be great. Thank you.
Erica, it's great meeting you. We've really appreciated your insights and contributions.
Thank you. It's been great to be here.
And really appreciate both of you being the driving forces behind Without My Consent. That's going to be a fantastic resource. Folks can find Erica at Erica J. Stone on Twitter. And again, her firm up in San Francisco is Ritter, Costa, and Johnstone. Thanks a lot.
Thank you.
And Evan, great to see you again, as always.
Yes, great to see you. This has been fun, hasn't it? It's great to talk to Colette and Erica. Great to talk with you again. Just can't pass up the chance to mention how I know Erica. We used to be colleagues, so to speak. This. That's right. At the good old days when she was with our firm, Hinshaw & Culbertson, in the San Francisco office, gone on to great things. So it's great to catch up, and it's been a wonderful conversation. So I've really enjoyed being here.
Thank you. Great to see you too.
It's been great having you all. And folks, you can find Evan at internetcases.com when he's not here on the show, and he's also Internet Cases on Twitter, where I am D Howell. And I'm Denise at twit.tv if you want to shoot me an email between the shows. Love to hear from you. You can leave comments on the shows where I post them over at my blog, bagandbaggage.com. We do have comments turned on over there. And we'd love it if you rated the show on iTunes. That's always fun. And come on over to our Facebook page, facebook.com/thisweekinlaw, where we have great discussions between the shows about things we're going to talk about and things that we're trying to understand a bit better. So with that, we'll say goodbye. See you next week at Friday, 11 a.m. Pacific, 1800 UTC at live.twit.tv when we record, or we'll see you in iTunes or the podcatcher of your choice, or on the device of your choice that gets MediaFly content such as the Roku. See you then. Bye.